Welcome to Spoken Injustice, where we put the criminal justice system in the dock. In today's video, we aim to provide an update on the issue of private prosecutions and potential reforms. We will start with a brief historical overview of prosecutions before delving into the surge in private prosecutions over the past 15 years. We will highlight the risk of creating a parallel prosecution system that serves commercial interests of elite groups rather than the general public interest and safety, and examine the government's response to this trend. And finally, we will discuss the Spoken Injustice reform proposal on private prosecutions. This video is packed with a lot of information, so grab a drink, perhaps a strong one, to help you get through it. As always, we recommend to stay with us until the end to ensure you have all the facts to reach your own conclusions. We have addressed the issues and concerns related to private prosecutions in several of our videos, which you can find in our playlist Private Prosecutions, linked below. We recommend watching these for background information and to gain a deeper understanding of the underlying principles and the related concerns. Now, let's start with a brief history of prosecutions in the UK. In the mid-18th century rural Britain, informal sanctions were often effective, and the formal criminal justice system was considered as a last resort. There were no professional police forces. Instead, law enforcement was primarily managed by local communities. Justices of the peace, typically amateurs with limited legal training, played a central role in administering justice quickly with minimal protection for the accused. Less serious cases were handled in quarter session courts, which were held 4 times a year in various regions, while the more serious crimes were escalated to the assizes courts. At this time, most criminals were prosecuted privately by the victims themselves, who often bore the cost of legal proceedings. At the beginning of the 19th century, rural Britain underwent significant transformation due to industrialization, shifting from an agrarian society to an industrialized one. This period saw a search for less cruel forms of punishment. There emerged a belief that institutions could rehabilitate individuals and address the root causes of crime, which was increasingly seen as a social problem influenced by various factors. Industrialized Britain indeed had both the means and the will to invest in this new approach, leading to the development of prisons, reformatories, and workhouses aimed at preventing crimes by addressing its social causes. At the same time, a modern police force began to take shape. Although some form of law enforcement in the UK dates back to the Middle Ages, it wasn't until 1749 that England saw the first indication of a contemporary police force, created by magistrate Harry Fielding, known as the Bow Street Runners. However, it was the Metropolitan Police Act in 1829 that established the foundation for the Metropolitan Police Force, widely considered the first organised English police service. By the end of the 19th century and the beginning of the 20th, the police gradually took charge over prosecutions, becoming both investigators and prosecutors in most cases. The Prosecution of Offences Act 1879 established the Director of Public Prosecutions, DPP. However, the DPP handled a limited amount of important and difficult cases. However, the police's dual role as an investigator and prosecutor led to a series of catastrophic cases in the 1960s and 70s, revealing a deeply flawed criminal justice system. This oppressive and unfair system ultimately necessitated reforms to separate these functions and ensure a fairer legal process. This arduous task was left to the Royal Commission on Criminal Procedure, chaired by Sir Phillips. Its findings were published in 1981. The view taken by the Phillips Commission was that prosecutorial independence, both from investigators and victims, constitutes the underpinning principle for a fair and just criminal justice system. This ultimately culminated with the Prosecution of Offences Act 1985, which created the Criminal Prosecutions Service, or CPS for short. This principle also inspired the recommendations made by the Gower-Hammond report in December 2000 and the Butterfield report in July 2003, concerning prosecutions conducted respectively by the then Her Majesty Customs and Excise and Her Majesty Inland Revenue. The Serious Fraud Office, or SFO, created around the same time as the CPS, was an exception to this model. Structured on the Roskill model, the SFO had prosecutors and investigators working together from the outset of a case. This departure from a truly independent model was justified by the complexity of fraud cases and the advantages of early cooperation between fraud specialist lawyers and fraud specialist officers. In the past 2 decades, the CPS has also embraced this hybrid model in most complex cases, becoming involved at an early stage of the investigation. Some of you have expressed concerns about this closer relationship, and no doubt this development may warrant closer scrutiny, as it might raise concerns about maintaining a truly impartial and independent prosecution. However, this issue lies beyond the scope of the subject matter here, and we will consider addressing this in a future video. Despite the close collaboration between investigators and prosecutors, and regardless of one's views on the current state of public prosecutions, both the SFO and the CPS are subject to inspections by His Majesty Inspectorate, judicial review, and scrutiny by parliamentarians, the media and the public, and most importantly, they are bound by a code of conduct. All aspects entirely absent in private prosecutions, as we will soon explore. Though the Phillips Commission deemed prosecutorial independence necessary and the basis for a fairer criminal justice system, private prosecutions were, however, not completely discounted, and provision was made in the same Prosecution of Offences Act 1985 at Section 6.1 to preserve the right of private individuals to institute and conduct prosecutions. Section 6.1 was introduced as a safeguard to individuals against public prosecution's inertia and state abuse. This is an important power that us private individuals wish to treasure and retain. In 2019, Mr. Justice Fraser's landmark judgment in the matter of Bates and others versus Post Office Limited, which found that the Post Office private prosecutions amounted to an abuse of process as the Post Office had failed to disclose flaws in its accounting system and to pursue all reasonable lines of inquiry during its investigation, led to concerns over the appropriateness of an organization prosecuting a case where that organization is also the victim and the investigator of the alleged criminality, calling into question whether the existing safeguards around private prosecutions are sufficient. These concerns were brought before the Justice Select Committee, which found that the Post Office was not the only powerful organization who was privately prosecuting. In fact, it found that in the last decade, private prosecutions have proliferated. These were not private prosecutions brought by individuals as a result of state inertia, but rather brought by powerful organizations who in most cases are the investigators, the prosecutors, and the victims, and who have other interests at stake. Surely the most appropriate forum for these types of disputes should be civil litigation, as they tend to serve not the general public interest and safety, but rather the agendas or commercial interests of elite groups such as the RSPCA. However, civil litigations are expensive. The reality is that the cost of a private prosecution, regardless of its outcome, can be recovered from taxpayers' central funds. Therefore, private prosecutions, much like public prosecutions, impose a burden on taxpayers, with the additional expense of private rates instead of the significantly lower legal aid rates. It's evident that law firms quickly began promoting the benefits and advantages of private prosecutions over civil litigation as a win-win situation. In 2019, an article published on the Corker-Binning website in the midst of discussion of the then decision of a possible private prosecution against Boris Johnson in relation to misconduct in public office reads: "Over the past decade, private prosecutions have become even more fashionable. Instead of using the civil courts, there is an increasing realization among lawyers and the general public that the criminal courts can, in the right case, offer an equally effective and certainly more dramatic means of seeking redress." And the article continues, "Perhaps surprisingly, the evidential threshold for obtaining a summons in a private prosecution is relatively low. Many applications for a summons are made on papers without the defendant being present or even knowing a summons has been applied for. Once the defendant becomes aware the trouble is brewing, his or her lawyers have limited scope to resist the summons. They can only argue, amongst other matters, that the essential ingredients of the offence are not present or that the allegation is vexatious. And Arwin Mitchell's website warns its potential clients that private prosecutions have become more common. We have seen more cases come to us. They add, companies often prefer to use private prosecutions because it's quicker and more efficient. Civil cases cost more and take longer. This trend even led to the creation of the Private Prosecutors Association, a membership organization for professionals with expertise in bringing private prosecutions and academics interested in this field. The association has its own non-binding code of practice and was created with the aim to bring together professionals with expertise in bringing private prosecutions and to recognize and promote best practice in this field. The PPA provides a forum for discussion, the opportunity to make collective representations on important issues affecting private prosecutors and prosecutions, and networking and educational events for members and non-members. In contrast, here is what the government, perhaps somewhat out of touch, says about private prosecutions. This page was published in February 2022. It's important to note that bringing a private prosecution is a serious and difficult step. Those thinking of bringing a private prosecution are strongly advised to seek independent legal advice from a qualified lawyer first. The person prosecuting will need to pay a lawyer if they want legal representation. According to the Ministry of Justice Legal Aid statistics, the average costs of a private prosecution are around £8,500. Court staff and judiciary cannot give legal advice to a prosecutor. The prosecutor must comply with all the relevant legislation, common law and rules, including the rules on disclosure and law of evidence. The court can order the Ministry of Justice to pay the prosecutor's costs at the end of the case, but this is not guaranteed. In some rare cases, the court may order the prosecutor to pay the defendant's costs. The Justice Select Committee found that in 2019-2020 there were 276 cost orders awarded to private prosecutions, 219 in the Magistrates' Court and 57 in the Crown Court, which resulted in payments from central funds of £1,169,000 and £11,180,000 respectively. Each private prosecution in the Magistrates' Court cost an average of £5,338 and each private prosecution in the Crown Court cost an average of £195,053. In its 9th report published in September 2020, at paragraph 77, the Justice Select Committee warns that it is incumbent on the government to ensure that the rise in the number of private prosecutions does not result in the development of a parallel system where the public interest, accountability and transparency are secondary to private interests. And at paragraphs 60 and 61, the Justice Select Committee made the following recommendations. The government should strengthen the safeguards that regulate private prosecutions to ensure that any organization that conducts a substantial number of prosecutions is subject to the same regulatory standards and expectations of accountability and transparency as public prosecutors. We recommend that the government should consider enacting a binding code of standards enforced by a regulator that applies to all private prosecutors and investigators. In order to achieve parity with public prosecutors, the duty to comply with the code should have legislative force. The aim of the code will be to ensure that all organizations which bring prosecutions respect the need for separation of investigation and prosecution and the need for objective and independent prosecution. As Wooler notes, a legislative code will not necessarily achieve the standards and consistency required. The code will need to be enforced by an institution or body with the requisite expertise and resources. The functions and responsibilities of HM Crown Prosecutions Service Inspectorate could be expanded to take on this role. They also recommended that HMCTS, that's the courts, establish a central register of all private prosecutions in England and Wales. The courts should also ensure that the CPS is notified when a private prosecution is initiated, and that every defendant who is privately prosecuted should be informed of his or her right to seek a review from the CPS. So what was the government response to this report? Well, the government response to this report was the establishment of a private prosecution register, which was implemented late in 2021, and the introduction of the Criminal Procedure Amendment number 2 rules, which came into effect on the 3rd of October 2022. And what do this rule do? Essentially, they amended Part 7 and Part 45 of the Criminal Procedure Rule 2020. Part 7 provides for the summons to identify who the prosecutor is, if the prosecutor is not a public authority, but also includes specific scenarios in which the magistrates' courts can refuse to issue a summons. A discretion that magistrates' court had prior to this change in any event, although admittedly some recent case law seemed to have been put that discretion into discussion. Some of the scenarios in which the magistrates' courts can refuse to issue a summons are, for example, whether the prosecutor fails to disclose all the information that is material to what the court must decide, or whether the prosecutor's dominant motive would render the prosecution an abuse of process. It is unclear, however, how in practice the magistrates' court is going to find out at this early stage of the proceedings, when the prosecutor fails to disclose all the information material to what the court must decide, or what the prosecutor's dominant motive for the prosecution is. Particularly when in most cases, and we've seen it before, this process is undertaken ex parte. That means without the presence of the accused. Arguably, the accused is the most likely person to know whether there has been any material information suppressed or what the real motive for a prosecution against them is. As per Part 45, this is in relation to court orders. This has also been amended to really be more precise in that it requires further information in relation to private prosecutors' cost. And so when applying or when requesting a cost order, that further information needs to be now included, and confirms that also the court can refuse such payment whether such information has not been provided, or even make an order for a lesser amount. However, in all, the government declined the imposition of a binding code for private prosecutors and declined to subject those organizations with a significant number of prosecutions to the scrutiny of any type of inspection. Whilst one can argue that the further request of the private prosecutor to justify a summons and the further request for detailed cost information in relation to cost orders are in principle capable of mitigating the number of private prosecutions, in our view, the only private prosecutions which are likely to be affected by these new measures would unsurprisingly be the genuine private prosecutions brought by private individuals who have genuinely been let down by the state. For instance, consider an elderly person who has lost all their pension savings to a heartless fraudster. The police show no interest in pursuing the case, leaving them no choice but to seek help from a reputable private firm. The firm will charge private rates, which is justified since the law firm shouldn't bear the cost of the state's inertia. However, they may have their costs disputed under Part 45 and even perhaps an order for a lesser amount. These concerns re-emerged earlier this year following the broadcasting of the ITV drama Mr. Bates versus the Post Office. Indeed, we drew attention to this in our video Post Office Scandal, when legislators, executive and judiciary fail to deliver, which is linked in the description below. And since then, on the 10th of January 2024, Sir Robert Neil MP, Chair of the Justice Select Committee, wrote to Lord Chancellor and Secretary of State for Justice Alex Chalk. In his letter, he asked Mr. Chalk to confirm data from the Private Prosecutions Register, such as how many prosecutions were brought between 2022 and 2023, details of the organizations who brought such prosecutions, how many resulted in convictions, etc. He also urged him to reconsider the recommendations made in the Justice Select Committee's 9th report, given the information that has come to light on the Post Office approach to prosecutions and the limited power of the justice system to provide safeguards to those targeted. He concluded by stating, "We recognize that Sir William's Post Office Horizon IT inquiry will make finding in this area, but we would encourage the government to use any bill to address the Post Office Horizon scandal to also strengthen the safeguards in place for those subject to private prosecutions." The Guardian reported headlines on the 12th and 13th of January 2024, respectively, as follows. Top lawyer urges MPs to review private prosecutions after Post Office scandal. Bar Council Chair Sam Townend KC says Parliament should consider formal regulation of growing practice. Despite the Post Office believing it was a victim of criminal behaviour, it was also able to act as prosecutor. Those bringing private prosecutions almost inevitably have a vested interest, and plans to reform private prosecutions after Post Office Horizon scandal, improved oversight and a law to strip organisations of their power to take people to court are among measures gaining cross-party support. Plans to overhaul the growing cottage industry of private prosecutions are already being urgently examined by ministers in the wake of the Post Office scandal, including measures that could see untrustworthy bodies barred from pursuing them. And on the 24th of January 2024, Lord Stone of Blackheath asked His Majesty's government, further to their response to the Justice Select Committee's 9th report, in which they confirmed that a register of private prosecutions would be made available, why this has not yet been made available, and when this is expected to be made available, and how much taxpayers' money was paid to legal firms prosecuting private prosecutions between 2015 and 2023. And this was the answer delivered on the 7th of February 2024 by Lord Stewart of Dillerton. In 2020, the Justice Select Committee undertook a review of private prosecutions and provided 9 recommendations. The government agreed to 2 of these recommendations: to introduce a central register of private prosecutions, and that we will take steps to ensure costs recoverable from central funds by a private prosecutor are limited in the same way as costs recoverable by an acquitted defendant. The register is not publicly accessible, and it was neither a recommendation made by the JSC report nor the undertaking agreed by the government for it to be. The register contains personal data, including where people have been accused of crimes where the court found there were no grounds to commence a prosecution. The register is a court record, and there are no grounds provided under Rules of Court and Data Protection Act 2018 or the Freedom of Information Act 2000 for these personal details to be released to the public. Requests for non-personal information from the register are accessible through a Freedom of Information request to HMCTS. The government is committed to bringing forward legislation to ensure costs recoverable from central funds by a private prosecutor are limited in the same way as costs recoverable by an acquitted defendant, and will enact this when parliamentary time allows. The assessment and payment of prosecutors' costs out of central funds for cases brought in the Magistrates' Court and the Crown Court is undertaken by the legal aid agencies LAA. Information about central funds expenditure, including private prosecutions, is published on a quarterly basis within the LLA's official statistics. Sir Will Williams' Post Office Horizon IT inquiry is examining in detail the failings that led to the Post Office scandal. It is possible that this will provide insight on the extent to which the private prosecution regime played a role in this particular injustice. The government is, however, examining the wider question of private prosecutions and is therefore committed to looking again at the Justice Select Committee's recommendations in their 2020 report as part of this work. And on the 25th of January 2024, Lord Weir of Ballyholme asked the government what plans they have to remove the power of the Post Office to bring private prosecutions. The question was answered by Lord Bellamy as follows. Whilst the vast majority of Horizon cases were prosecuted by the Post Office, some were pursued by other prosecutors, including the Crown Prosecutions Service. The Post Office does not have a specific power to bring private prosecutions. It did so under the Prosecution of Offence Act 1985, the same right as other third-party organisations such as the RSPCA. The Post Office has not brought any prosecutions since 2015. And then note the last two paragraphs, exactly the same as in the previous reply, restating that it would be inappropriate for the government to preempt the findings and recommendations of the Post Office inquiry, which are due later this year, by pursuing changes at this time, and reconfirms that the government is, however, examining the wider question of private prosecutions and is committed to look again at the Justice Select Committee's recommendations in their 2020 report. Recently, aside from an optional session held in the afternoon of the 8th of June 2024 at the Bar Council conference focused on reforming private prosecutions in the wake of the Post Office scandal, the initial enthusiasm for addressing concerns about private prosecution brought about by the Post Office ITV drama seems to have faded into deep oblivion. This decline in interest was partly justified by the inappropriateness of the government addressing this issue whilst awaiting recommendations from the Post Office inquiry due later this year, and more recently due to the upcoming election. However, after closely examining the major parties' manifestos ahead of the 4th of July election, it appears the private prosecutions are not on any of their priority lists and seem to have been overlooked. While we await the election results and the establishment of a new government, we have taken the time to draft our own reform proposal on private prosecutions. This is an appropriate time to also let you know that we have a new tab on our website dedicated to our reform proposals. Indeed, our proposals on the compensation scheme was unveiled in a video aired 2 weeks ago, which you can find linked in the description below. We also refer to reform proposals by other parties that we fully support, such as, for example, the doubt dismissed campaign by appeal. We encourage you to review each proposal carefully and share your feedback in the comments section below or through our website or our networking hub. Additionally, if you are enjoying this video, your likes greatly support the growth of our channel. And don't forget to subscribe if you have not done so already, and click the notification bell icon below to stay updated on our future videos. Now, returning to our private prosecutions reform, it is crucial first and foremost that we clarify the scope of our proposal and the types of private prosecutions it addresses. We want to assure you that we do not intend to attack the right to private prosecutions afforded to individuals as a fundamental safeguard against state power, state abuse, and public prosecution inertia. This is a right too important that we treasure and wish to retain. Our reform targets private prosecutions initiated by powerful organizations whose interests do not align with safeguarding the public interest and safety, but instead serve their self-interest, whether commercial or ideological, aimed at asserting their power and influence. Having defined the scope, the requirements we propose are simple. First, to ensure the private prosecutions are pursued only when absolutely necessary, we propose the private prosecutions be subject to a prerequisite of showing that there has been effective inertia or inaction on the part of public prosecutors. This requirement will entail private prosecutors providing evidence that public prosecutors have failed to act on a case despite sufficient grounds for prosecution. This could include documented attempts to prompt action from public prosecutors, showing a clear pattern of neglect or refusal to proceed with a legitimate case. It would also entail establishing a legal standard or threshold that clearly defines what constitutes inaction or inertia. This threshold will need to be met before a private prosecution can be initiated, ensuring that the process is not misused. A judge or an independent body reviewing the evidence of state inertia to verify that public prosecutors have indeed failed in their duty before allowing a private prosecution to proceed. So that's the prerequisite. Secondly, to align private prosecutions with the standards of public prosecutions, it is proposed that private prosecutors be subject to a mandatory binding code of conduct similar to that which governs public prosecutors. These would include implementing strict ethical guidelines that private prosecutors must follow, ensuring fairness, integrity, and respect for the rights of the accused, will entail requiring private prosecutors to possess specific qualifications and training comparable to those required to public prosecutors. It would entail establishing clear rules to prevent conflicts of interest, ensuring the private prosecutors act in the public interest rather than for personal gain or vendetta. Thirdly, to prevent abuse and ensure accountability, it is proposed that private prosecutors who engage in a high volume of prosecutions annually be subject to an appropriate and regular inspection and scrutiny. These would involve setting a specific number of cases per year that triggers mandatory oversight. For example, any private prosecutor handling more than a defined number of cases annually would fall under this regulation. And it would entail conducting regular audits and inspections of the activities, case files, and conduct of these high-frequency prosecutors to ensure compliance with legal and ethical standards. It would entail mandating frequent private prosecutors to submit detailed reports of their activities to a regulatory body, which would review these reports to detect any pattern of misuse or abuse. It would entail establishing clear disciplinary measures for private prosecutors found to be violating standards or engaging in misconduct, including suspension or revocation of their right to prosecute privately. Additionally, we propose that legal advisors, whether barristers or solicitors, who take on private prosecutions should have their fees capped at the same rate as public prosecutors. This measure will enhance public trust in the private prosecution system by mitigating concerns about profiteering and ensuring that prosecutions are conducted fairly and ethically. Furthermore, it will reduce the incentive for solicitors to pursue private prosecutions solely for financial gain, thereby encouraging prosecutions that serves the public interest rather than being driven by the prospect of higher fees. By implementing these reforms, the aim is to ensure that private prosecutions serve as a necessary and justified complement to public prosecutions rather than an avenue for potential abuse or misuse. This approach seeks to balance the need for accountability and justice with the protection of legal and ethical standards in the judicial process. I hope you have found this video informative and interesting, and if so, like it and subscribe to our channel to help us in our mission to humanize our criminal justice system. Also, join our networking hub at spokeninjustice.net to have your say as to the content of this channel. We look forward to usher you as we sit and rise in this unique trial.